All right, peace to the gods, Yusef here. Today, I want to answer a question from a viewer. They had a question for me about promissory notes. I don't want you to think that I didn't see your question in my DM. I did see the question. I see a lot of the questions. I do read a lot of questions. I don't necessarily always get to answer the question directly, but a lot of times if I get a lot of people asking me the same question, I'll go ahead and make a video on it. And I'm gonna try to get back to that practice. But I'm also gonna make this a practice. I think this is a very effective way on the internet, especially on Instagram, to answer some questions. And what this person, let me tell you what this person is asking a question about a promissory note. They were attempting to do an administrative process in order to receive, I guess, from, looking at the question, to get some sort of verification of debt. I don't know exactly what the issue was. That wasn't told to me. I don't know if they were in a foreclosure or, if they're just verifying the debt, trying to discharge the debt or whatever, but they said they were doing an administrative process. A lot of times people say they're doing administrative processes or they're doing something correctly, and then when I see it, it's not done correctly. You have to understand when you're doing an administrative process is essentially establishing evidence for the record that you have indeed given notice to a particular individual about a certain issue, whether it be the enforcement of a right or or to acknowledge something, just simply asking me something. They have to have a duty to respond. Now in Georgia, we have failure to answer a business letter. Here is the actual official code of Georgia annotated. This follows the principle that silence is acquiescence. All right, I'm sure all you attorneys out there, you know what I'm talking about. If somebody has a duty to respond and they fail to respond to you, then they agree to the contents of the correspondence that you submitted to them, as long as it's within the bounds of the law and reasonable. And it is quite okay to ask somebody for damages if they are corresponding with you or they're trying to take some of your property or trying to take you to court. Always enter a counterclaim in court when you go to court, when somebody sues you about something. Always enter in a counterclaim as a defense. Always put in a counterclaim. All right, but let's look at this question real quick and let's see exactly what it is. It's about a mortgage. Thank you for responding. My first notice was request for inspection of my wet ink original promissory note. I made sure to state in the first letter that a copy or affidavit of loss is not acceptable. I asked in May, I guess for one other signature. I'm asking me, and one other signature was on it that wasn't on my documents I have at home from closing. So I guess right here what she's trying to say is that, she got a copy of her documents when she originally bought the home. They provided a promissory note, and it doesn't look anything like the original promissory note that she had when she got it closing. It says, then I sent in my first notice to start the administrative process, and they responded this week with another promissory note where they added original at the top. That isn't on mine's or the other two they sent me with another signature added. May 31st, 2 signatures on the page. June 8th, 2 signatures on the page. July 18th, 3 signatures on the page. I've been up all night studying and reading case laws, trying to figure out how they can add 2 signatures without me being present. I thought a contract consists in both parties signing. Okay. Let's try to answer this. What a contract does require offer, acceptance, and consideration. It requires 2 people who are mentally competent to enter into a contract. That's why people who are under 18 aren't allowed to contract. So you have to reach the age of majority and, demonstrate that that you understand exactly what you're engaging in. It's going to be a presumption that you do at least. And you have a contract, an agreement of the parties that is enforceable in a court of equity. Now, as far as the fraud or the attempted fraud that I think that you're alleging in your correspondence, you have to have evidence of that, and you have to have verified evidence. In other words, if you have a copy of something, you have to have it verified by a notary. Notaries can make copies of documents for you. They can send you something in the mail and say, well, hey, we don't know where that came from. So you are receiving something, you always make sure that you request that somebody with the ability to bind the corporation contact you, and make sure that when they do send you documentation, that it is signed in wet blue ink by a representative officer of that corporation. Also, all your correspondence should be going to your notary's P.O. box. No correspondence should be returning to you. When you go into court, you need 2 witnesses. Your first witness is the notary. That's in the capacity that they serve as a witness. Your second witness is the 3811 green card form that you send in the mail that you have returned to you. When you go into court, both of those need to be submitted as exhibits in your complaint or in your counterclaim argument that you're presenting in court, that you corresponded with these individuals and that you asked them to explain. Like I would make copies of everything that you say they added the signatures, and I would ask for an explanation and see what type of explanation that they give me. I would send it by a notary presentment with an affidavit of mailing, utilizing certified mail with a 3811 form, and I put return receipt requested and my address on the back. Those green cards that you have to save those as evidence. You need 2 witnesses. 2 witnesses come from the Bible. Okay, that comes out the Bible. Understand that the laws in the United States are based off the Bible and Williams Blackstone commentaries that comes out of England. All right. So the administrative process is an evidence gathering tool. It is not a panacea or cure-all for everything that ails you. All right. So understand that you're attempting to get evidence. So when you go into court, that you already have your evidence and you already have an agreement of the parties. This follows the principle that is in Matthew 5:25, where Jesus said, agree with your adversary while you're on the way to court with him, lest he hand you over to the judge hand you over to the bailiff, and the bailiff cast you into prison. I tell you, will not come out until you pay the very last farthing. Farthing means penny, the very last penny. So we're talking about debtors' prisons. All right, but the key to that scripture is that there must be an agreement of the parties. This is the whole point of you doing an administrative process, not for you to get into an argument with these individuals and so forth. They're either going to answer or they're not going to answer, all right, or be non-responsive to what your requests are. So when you mail something out, you are not the one that's mailing it out. A lot of times they will not respect you and your request because you don't know what you're doing. You don't know how to submit correspondence. You don't know how to draft correspondence. One of the best documents that you can get that has a lot of pre-written correspondence in it is the Banker's Secret Manual by Tom Schaaf. Also, Tom Schaaf has one of his proteges. I have him on my website on YouTube. Here he is right here. You need to watch this video. It's called The Money Matrix, where this is an accountant who is a CPA. He's explaining to you the matching principle and how they really don't loan you anything. Okay, for all of you out there try to say this is some sort of a vapor money theory, well, here's one of your own who is a CPA. I think Tom Schaaf them got into trouble doing this, but it's providing you the truth. Also, you can look at FASB 95 on page 21, where they explain how under financial institutions, where they explain how money is created. You can also read Modern Money Mechanics. You're going to get an explanation in there, and you can use that as an exhibit, the Affidavit of Walker Todd. Always make sure that you have the Affidavit of Walker Todd as an exhibit anytime you feel like you're going to be challenged by them using some sort of vapor money theory. You need some sort of expert witness on your side, and that affidavit from Walker Todd, who is an attorney worked for the Federal Reserve, will fit the bill. Okay. Now, as far as the case law that you're looking for, you can find that you have to understand principles of law. Don't look for something that when you're looking at case law, you do want to try to find something that matches your particular matter in your state. The best online resource that you're going to find for free is Google Scholar. Google Scholar. Go over to googlescholar.com and you can look up case law, state specific as well. Okay. Now, here in Georgia, I'm going to give you an example of something. You can look in Georgia that will probably help you. And the name of the case is Igana versus HSBC. In that particular case, the judges gave Igana the answer that he was looking for, and that's called an affidavit of forgery. You have to understand that you have to require them to submit the originals. What you are making is a produce the note argument, that if you don't have the note, then you don't have any rights to receive any payment from me because you're not the holder in due course or holder of that particular document. All right. So that's why you're asking for the proof of that. Now, they have laws in your states that allow them to submit copies of documents to you if you don't challenge it. If you challenge it, then they have to account for the original. That's what these laws are here in Georgia. Now, you can't use Georgia laws. It will only be considered comity, which means that if they did honor a law from another state, it will only be because out of respect for that state, but they don't have to. All right. You have to use stare decisis that is in your particular jurisdiction. That means a matter already decided. All right. So understand that and understand these words. It's a good thing that you're out here, trying to do things on your own and find out things and that you're going to study. Hopefully, these points will help you out a little bit. And also go to my website and look at my YouTube page and look at the administrative process video I have on there. I have a couple of videos on the administrative process. You need to look at those videos and understand what you're doing in your correspondence. You can break out the correspondence, the different sections of the correspondence. Hope this helps everyone. My name is Yusef. Peace to the gods. I'll see you on the next video.